Malad, may I have Malad's kind leave, Malad, to mention IAGA number 8 of 2021, Malad. I was praying for drawing up and completion of the order, Malad, dated 29th of February 2024.
Check it.
Malad, if the leave may be endorsed, I had already applied for the certified copy, but it cannot be drawn up until unless the leave is granted by your lordship. Because the 7 days time, Malad, to apply, Malad, has expired.
May our lordships kindly leave to mention one
Grateful.
suit matter, my lord.
On notice?
On notice, my lord. My lord, this matter is was appearing before Justice Rao, my lord, for witness action, my lord. The matter was fixed on 4th, my lord. But due to change of determination, the matter could
Come in this. Check it. Fix a date.
Your Lordship, may I permitted to mention two matters from
On notice?
Yes, Your Lordship.
notice?
Other side is here. Your Lordship, from today's list, item number 8 and 9, which is fixed under the heading Witness Action, Commercial Division. Your Lordship, my witness is unable to come, Your Lordship, as he is not well. Your Lordship kindly fixes a date on Monday, Your Lordship, if allows.
Monday,
Yes, Your Lordship.
not this week.
Your Lordship, may I permitted to file our compliance
On
for the
that date.
commercial division? Oh, grateful, Your Lordship.
My lord, I am for the defendant. My lord, at the first, my lord, I apologize, my lord. On the last occasion, I was not here, could not appear, my lord. My lord has permitted us to file an affidavit in opposition within 2 weeks, but within 2 weeks we could not.
My lord, I am for the
file.
plaintiff, my lord.
And my lord, it has been served already, but without the leave of your lordship, I cannot file the opposition. That is what the matter. If your lordships kindly allows me, then I will file an opposition.
They have filed an affidavit, my lord. My lord, no reply need to be filed, my lord. Your lordship can take up the application.
Affidavit in opposition was to be filed within 2 weeks from the date. That
Yes.
means
They are
from
out of time, my lord.
20th
Yes.
February.
Yes, my lord.
This is today's.
No, my lord, it has been informed earlier. It has been informed earlier.
I directed to file within 2 weeks.
My lord, that's what I started submitting that, my lord. I
am giving you 1 week time. Either
I'm
file or
re-
I'll hear.
I'm ready with this.
Will you fight today?
Yes, I'm ready with this. I have already served to the other side.
Affidavit, any reply?
No, I need not file any reply, my lord.
Affidavit in the opposition is filed today. Let the same be kept in record. The learned counsel for the plaintiff submitted that no reply would be filed on behalf of the plaintiff. And both GA7 and GA8.
No, only in GA8, my lord, my landed friend has filed affidavit. GA7 affidavit was filed earlier.
My lord, GA7 is an appointment of the commissioner.
That was allowed.
The time is being extended from time to time.
For examination of witness.
Yes, because it was already fixed for witness action.
Okay.
Then
that's going on.
thereafter, my learned friend has filed this application for disclosure of documents.
All right. It will appear on the list for hearing on today is 10th, 19th, 19th April.
19th.
Lordships kindly allow.
Sir, your lordship can take it up night now. Mr. Mukherjee has come, my lord. We need not file any opposition, my
No,
lord.
not right now.
My lord, if it could have been 22nd, my lord.
22nd.
22nd, my lord.
All right. 22nd.
I will no reply, we will file. What opposition time change? That one is time to expire.
My lord, 22nd then, my lord.
22nd.
service.
Lordship, I am appearing for the defendant. Lordship, the advocate on record, Mr. R.L. Gaggar, has passed away, Lordship. So I need your Lordship some time to take necessary steps to file fresh wakalatnama, Lordship.
This
On prayer of the learned counsel for the plaintiff.
No, Mr. R.L. Gaggar is the advocate on record.
Mr. Gaggar was advocate on record.
Yes, Your Lordship.
His son was possibly, I don't know, my lord, might be.
Lordship, Mr. R.L. Gaggar was the advocate on
Well,
record.
How long would you take?
Lordship, 3 weeks.
Not
Lordship,
3.
we have to take instructions, Your Lordship.
Can
2
we
weeks
see
is
the
too much.
previous orders, my lord?
3 weeks is too much.
Lordship, then
A submission was made that his son has been empaneled, so he is not. It's very confusing. It was previously said that Mr. Gaggar's son is now the advocate, but since he is an empaneled advocate, he will not be.
Lordship, but we later found out that Mr. R.L. Gaggar is
2
the
weeks
advocate.
time. I'm giving you 2 weeks time.
Lordship.
Well, I have some prayer, my lord. My lord, our affidavit of truth is ready. My lord, the advocate, the wakalatnama is also ready. My lord, there are in the competency.
I'm on the next date.
Well, it's very small prayer, very small prayer. I may just want leave to file this. Well, the seal of the under secretary is not there, my lord. The seal. Well, he has written my lord.
How can it be accepted then?
Well, he has said only on this.
I'm fixing another date. Get it signed. Get it sealed.
My lord. Right.
Adjourned to 30th April.
Grateful, Your Lordship.
My lord, I am appearing for the plaintiff. I'm led by Mr. Thakkar. He is online, and my lord, our affidavit of evidence.
Yeah, I am being served right here.
You are the plaintiff.
Yes, my lord.
Are you the plaintiff?
Yes, my lord.
Would you cross-examine today?
Your Lordship,
Or
it has
take
not
the-
yet begun. The examination has not yet begun only. I have been just served here and now with the affidavit of evidence.
When will you come?
Your Lordship, they have to
Documents are there.
initiate.
Documents are to be adduced.
Yes, Your Lordship.
My lord, we've proved. Sorry, my lord, I'm not keeping well, my lord. That's why kindly permit me to appear, my lord. Documents have to be adduced, my lord. Most of them are by secondary evidence. I tell you, lordship, in very one sentence, my lord, what the transaction was. So transactions under 6 letters of credit.
Produce these documents today or not? Tell me that.
My lord, I have adduced the documents in my chief, my lord. If your lordship wants, then my lord, kindly pass it over once, my lord. I have an appointment now with the doctor. I'll just finish that and come, my lord. Kindly pass it over once. My witness is there.
Adduce documents. Will you come today? Today I am not possible. I have other matters.
My lord, then kindly give a date, my lord. My witness will come. I will.
Evidence on affidavit is filed today. Let the same be kept in record. On prayer of the learned counsel for the plaintiff, the matter is adjourned. Suit is adjourned to 16th April.
Grateful.
Where is your other side?
Just fix it 11 minutes, still 10-15 minutes are there.
Dimnath Chaudhary is appearing for the petitioner, my lord. One.
Where is your other side? Pass over. Item number 3.
Your Lordship, I'm appearing on behalf of the receiver, Your Lordship. Your Lordship, in this matter, Shananda Mukherjee was appointed as the receiver, Your Lordship, by an order dated
Where are the parties to the
February
suit?
2012, Your Lordship. 6th February 2012.
Yes.
She wants to retire from this
Where are the
appointment.
parties?
Your Lordship, in the meantime, what happened, Your Lordship, when she gave notice for mentioning, Your Lordship, he searched the list and found out that 2 orders have already been passed in this matter, Your Lordship, dismissing the suit, Your Lordship. And one of the order was passed on 5th May 2014 by Honorable Justice Shomin Jain.
I appear for the defendant.
Your Lordship, in that matter, on that day, Your Lordship, the suit was dismissed for default, Your Lordship, and all interim orders were vacated, Your Lordship. Then subsequently, Your Lordship, on 6th of January 2023, This matter was again dismissed for default, Your Lordship, by Your Lordship, Your Lordship.
That order was not produced before this court.
We don't know, Your Lordship, because we are
Can you
appearing
give
for
me
the
the copy of this
receiver.
order?
We have given to the court officer, Your Lordship.
Ma'am, you are.
We can give the copies also if you want. No, receiver.
But the plaintiff, as per my knowledge, is not appearing and a receiver is appointed in this matter. I appear for the defendant. The suit was.
Should be discharged.
Yes.
Yes, Your Lordship. But Your Lordship, there is an amount lying in the fixed deposit, Your Lordship, in the receiver's account, Your Lordship. That was 6 lakhs at the time of appointment, and it's now 15 lakhs 30,000 and odd, Your Lordship. So, what to do with this amount, Your Lordship? Because this was.
That should be deposited with the registrar original side.
Yes, Your Lordship.
Lord, in case the suit is being dismissed for default, then Lord, that amount will be returned to the party.
Your Lordship, that we don't
Subject-
know, Your Lordship.
No, that let the claim, proper claim come.
Very well, Lord.
I cannot adjudicate that in a dismissed suit. Give me the copies of the order.
Yes, Your Lordship, I'm giving it, Your Lordship. But and Your Lordship, according to the order, Your Lordship, the remuneration was to be deducted from the fixed deposit, Your Lordship, at the end of 1 year, Your Lordship. So that is pending, Your Lordship.
The instant suit was dismissed for default along with pending applications on 6 January 23. The learned counsel appearing for the receiver. Where is the order of appointing receiver?
Your Lordship, it's
handed over. 6 February 2020.
Not a choice. Lord, may I have my Lord's leave? May I have my Lord's leave?
You the learned counsel appearing for the receiver submitted that in view of dismissal of the suit, appropriate order may be passed. Full stop. Next para. The present receiver is Shananda Mukherjee.
Shananda Mukherjee.
Present receiver was appointed in terms of order dated 6/2/2012. It was clarified that the new receiver, namely the present one, will be entitled to remuneration at a rate of 100 GM per month to be first realized at the time of the first renewal of the term deposit and thereafter at every renewal. You furnish a statement, how much have you received?
All accounts are
How much have you received? There is an order. At the time of renewal, this amount is to be, remuneration is to be deducted.
Yes, Your Lordship.
Furnish a report.
Accounts have been filed, Your Lordship.
and passed.
Supplementary affidavit, how much you have received as yet. Not detailed account. Is it there? How much have you?
It's in the accounts, Your Lordship. We had filed the accounts.
Huh? The learned counsel for the receiver submitted that statement of accounts has already been filed. Full stop. However, The same is not placed before this court today. Department is directed to place the statement of accounts before this court along with the record on the next date.
Your Lordship, we have the last accounts, Your Lordship.
That is not with me right now. Case record is not with me.
Your Lordship is keeping the next date on.
The matter will appear in the list for further order 19th April.
19th. Grateful.
Lordship, item 4, I am for the plaintiff, Your Lordship. Lordship, in this matter, there was a stay from the Supreme Court, Your Lordship, stay of the proceedings since they had.
I am for the defendant number 1, my Lordship.
Lordship, now the Supreme Court has passed the order, Lordship, dismissing their transfer petition. I am handing over a copy, Lordship.
My Lord, we intend to file a written statement. Kindly give us a fortnight, my Lord.
It is state in terms of the order dated
6 March
2024. 6 March 2024, Your Lordship.
when the transfer petition was dismissed.
Lordship, I am handing over the copy of the order, Your Lordship. It was dismissed on 6th of March 2024.
So there is no further stay.
No further stay, Lordship. It has been dismissed.
So let it come in the list. What is the stage of the suit?
Lordship, we have served our summons. The written statement are yet to be filed, Your Lordship.
And kindly give us a fortnight to file a written statement, my Lord.
The learned counsel for the defendant please leave to file written statement and also hand over a copy of order dated 6 March 2024 passed by the Supreme Court of India. Stay order was passed earlier.
Stay order was passed earlier.
In terms of the said order, the transfer petition was dismissed. As such, there is no stay, as submitted by the learned counsel. Full stop. The learned counsel for the defendant craves leave to file written statement. The same should be filed within 7 days. The suit will appear in the list on 19th April for further order.
Grateful, Lordship.
Wait, please, Your Lordship.
No, not this one.
My Lord?
Not this one. Item number 7. It is 11 now.
We should take up the fixed matter, my Lord.
Mr. Ghosh, I don't think you have a good chance. Still, you may come.
My Lord, ours is immediately the next matter.
It will not take much time, my
But
Lord.
it will take little time. It's fixed at
We'll
11.
wait for a chance, my Lord. The prayer is very innocuous, though.
The same one.
No, my Lord, it's a different matter. But then I don't think that anyone would be
Anyway, let-
prejudiced
let
by
it
the
be
prayer.
which
We'll
way
take
should
our
be
opportunity.
taken,
We'll take our chance.
Yes.
We'll take our chance.
Item number 1.
Let it be taken up first, then it will be looked into. Item number 1 of regular list. Kept Passover.
The learned receiver has come, my Lord. The learned receiver discharge here.
When it will be called, then I will check it. Item number 7.
Yash Asai.
Where is your other side? Mr. Ghosh, you come at about 11:30 or 11:45. It will take time. At least. It will take 11:30 or something more.
How much
You
time
finish it today.
At least first half. Close back, please. Mr. SI, I put it to you that all the agreements in respect of the suit films are between the producers of the said films and the Gramophone Company of India Limited.
Yes.
Can you explain to the court the relationship between Gramophone Company of India Limited and the plaintiff company?
So plaintiff company is the same company as Gramophone Company of India Limited. In the year 2000, there was a name change from Gramophone Company of India Limited to Saregama. From Gramophone Company of India Limited to Saregama India Limited.
So it is correct to say that Saregama steps into the shoes of Gramophone India Limited so far as the rights are concerned.
It's the same entity.
Okay.
It is the same entity.
I draw your attention to Exhibit H, page 24 of the judge's brief, volume 1. Twenty. 24. ED5, page 24. I draw your attention to clause 2 of the agreement. This under clause 2, I put it to you under clause 2, the producers obligated to supply performers and musicians for recording of the song for the purpose of making gramophone records. Is that correct?
Correct.
The cost of the said recording was to be borne by the producer. Is that correct?
I'm not aware.
As per the clause.
Whatever is there is there.
You confirm answering.
Document and answer the question.
And this is the interpretation of document done by this court. Already document.
Say yes or no.
Whatever is there is there.
Mr. Asai.
Yes, as per the document, yes.
Are you, given your long experience in the music industry, are you aware of the process of recording of a song?
To some extent, yes.
Is it correct to suggest?
Please be slow.
Malot, the time is short. I have many questions. I'd come for 2 full days.
Go ahead.
But
I'm specially accommodating you.
I'm grateful for that. I bow down to the court. Is it correct to suggest that all performers and musicians sometimes rehearse before recording is made?
Yes.
And I put it to you that sometimes many versions of performances are recorded to choose the best for making of the master.
Yes, multiple scratch are recorded.
From scratch, you mean non-final versions?
Yes.
Final versions.
Correct.
Version of song.
Recordings.
Non-final version of song.
Performance is recorded.
Better used to what this song.
So, song is of the song.
That will explain a lot of things.
And this is also captured in clause 3 of this agreement, which makes an obligation for recording of several versions. Do you agree with?
Several scratch, yes.
And in this clause,
by scratch you mean songs, non-finalized songs.
Non-finalized songs.
now every time a person performs, which is sings, sound waves are created, which is picked up by microphone and fixed in a master. Now many versions are created and they hear and choose the best one. So my saying the process of creating the final song, many versions of sound recordings are created, which he's confirming. They call it scratch in the industry. I put it to you, by the word scratch, you mean what is understood in the industry as a non-final sound recording.
Yes, correct.
I put it to you that under this agreement, this was not the only option given to the producer for making of the gramophone records in terms of clause 4.
Correct.
I put it to you that clause 4 of this agreement provided the producer to submit the master that was created to be incorporated, master of the song created to be incorporated in the soundtrack of the film.
Can you repeat the question?
Can you repeat the question?
Provided the producer and submit the master of the song that was created
Recorded to be.
Recorded to be incorporated in the soundtrack of the film.
No. The option here is to deliver the soundtrack of the film from which a sound recording master can be created by the plaintiff company.
Okay, have you? So it is correct to suggest that soundtrack of the cinematograph film could be utilized for creating, master for mass manufacture of gramophone records.
No. Because a sound recording master is different than a film master. Is different than a film master. Sound recording master is different than a film master.
This master was derived from the sound recording submitted by the producer.
Yes, the sound recording master was recorded from the film master.
I put it to you that many times the songs recorded for the soundtrack of the film was used for manufacturing gramophone records.
The sound recording master created by the company was used to manufacture the gramophone records. The gramophone records.
And this was not, I put it to you, that this was not fresh recording.
Yeah, not a fresh recording. Yes.
It is correct. I draw your attention to page 150 of the judge's brief, volume 2, which was, well, this is the inlay card which was exhibited. Certain material exhibits were exhibited. This was inadvertently not marked. It should have been exhibit O. Mr. Ghosh will see. The
original, so original has to be marked as exhibit. Now, if you want,
I'm not contesting the document, Malad. I'm confronting the document.
this can be marked as exhibit.
Do
by
one thing, you
consent.
continue this one.
I want to continue. I rely on this document. The colored photocopies, that's good for my purpose.
I don't have the original. It's 1957, Millard. We don't have original.
We're not disputing it.
But you want to ask.
So I want to confront the witness with this.
This will go as his exhibit.
These are not exhibited.
It's not exhibited because it is their document. They did not get the original, so it was not marked as the exhibit.
So in that case, it will be marked as exhibit for the defendant.
For the defendant.
I did not have it, Millard.
I'm not disputing the document. The
For
copy is a true copy.
Defendant number 1. Have you produced any document here?
No, no.
No, not yet.
So for us?
No,
No, no.
he has
So it will be one series.
material exhibit 1.
And do you have a colored copy for his?
Can I give my copy?
Is that a colored copy? The judge's brief? Colored copy. Okay. 150. 150.
150. Color. He has a color.
Okay. Then. Volume 2, no? Volume 2. 150 is both, no? It's one page. This one. 150. 150. Mm-hmm. I put it to you that the H, the meaning we saw, but which is from Dunya.
Can I see the?
As you can refer to the plain para 6 where this is document dated 9 September 1968.
Yes.
Are you relying on this document?
I'm suggesting that the inlay card which I just shown you at page 50 pertains to this movie.
Yes, correct.
Exhibit 1.
Exhibit 1.
Continue marking in this way.
Okay, sorry. Actually, my lord, there's so much of glass and the visibility is affected, so I can't clearly see what is happening. Also, the mortar heights.
You may come here.
Can I come on this side?
Yes. You have to change the microphone.
Because the eye contact with the steno is important so that the speed is maintained properly.
Take care of the microphone this side. Mr. Bhattacharya, have you seen Dunya?
I haven't seen.
You have seen possibly.
My grandfather may have seen.
I am Millard, but from after 1975. I have seen those movies.
This is Calcutta was the center of culture in India then. Everything cultural,
New
movie,
theatres.
everything was created from here. And when Bombay was established by people who migrated from Calcutta.
Yes.
I was personally excited to do this matter because I get to come to Calcutta for this matter.
Still now, my lord, the music industry is still dominated by Bengalis, the singers.
Mr. Asai, you've seen the inlay card? I draw your attention to the blue square photograph cover. Can you please, for the benefit of the court, read what is written at the bottom in white?
From the original soundtrack.
At the bottom. Can you read what is written at the bottom on the inlay card?
From the original soundtrack.
Mark it, encircle it.
So please, sir, insert.
Document exhibit 2 or 1?
One.
One, and that part one by one.
One by one. I put it to you that in this case, at least, the gramophone records were created from the original soundtrack of the film.
No, as I said, a sound recording master was created, which was based on the recording made from the soundtrack, on the recording from of the soundtrack of the film.
On the lighter note, Lordship looks at the page 150, right hand side. Gramophone Company of India Limited. Lordship's brief. Dum Dum India. So this was the music hub. Jassore Road.
Jassore Road.
Every Millard, all cassettes.
Live house.
Millard, it continued till Millard T series came in the picture in 1987.
Yes.
On what basis do you say that?
Because a film master is different from a sound recording master, and to create a gramophone record or a CD or a cassette, a sound recording master is required.
We have cloud, we don't even have this.
Can you please read the answer so for the benefit of the court?
Sound recording master and to create gramophone record of CD or cassette, sound recording master is required.
Yes.
I put it to you that plaintiff now is also producer of films and owns the production banner Yoodle Films. Banner YOODLE Films.
Yes.
I put it to you that it also acquires films produced by third parties.
Yes.
I put it to you that the third party producers supply the master for exploitation of music rights therein.
They supply the master of the film as well as the soundtrack, which is the current practice in the industry.
I put it to you that your answer to the above question, where he said that when I asked on what basis he says, was not based on your personal knowledge in 1958. Oh, sorry, wait, the year is? (1968).
But the question was related to Udley Films.
No. The first previous answer about option B, where the producer, and I've showed you the inlay card, that that album was made from the soundtrack supplied by the producer for Dunia.
What is your question?
My question is, when the clarification he gave to my question on what basis he says was not based on his personal knowledge
Refer to question number.
at the time. Question number is not being announced, so we don't know which question. On what basis do you say so? I've asked that question 3 questions ago. Question number, what can you? How? Are you putting question number? Okay. That we put an asterisk there and then put a linking, put a mark there. I'm referring to this question, answer to this question. He's not on your personal knowledge, just to finish it there. On your personal knowledge.
Yes, I'm not aware as to what was delivered in 1968. However, I have personally seen the sound recording master in our archives.
That will go.
In our archives.
In our archives.
I put it to you, referring back to the exhibit H. Now come back to the document.
I have taking a lordship's kindly, my junior.
The same exhibit one.
Exhibit H, Dunia agreement. Coming back to that, I'm going to show various parts of the agreement to build my case. Please refer to para 5 on page 25 of the judge's brief, volume 1, which is para 5 of the agreement of Dunia.
Exhibited document.
Exhibit H, same exhibit H. On the same document, original agreement. Clause 5, sir. I put it to you that under this provision, the producer was not permitted for a limited period of 7 years to create a competing sound recording than given to the plaintiff.
In this specific provision, yes, but by virtue of the rights assigned under the contract, assigned under the contract, the producer was prevented during the period of the copyright to create any masters.
I put it to you that in terms of clause 6, after 7 years, for the period of 7 years, not during this period of exclusivity of the plaintiff was obligated to pay royalty as contained in this clause to the producer. obligated to pay royalty to the producer as contained in this clause?
Just till the time the records were being sold. Records were being sold.
I put it to you that the rate of royalty contained was 2.5% per side of the gramophone record sold.
Yes, it is 2.5% per side of the record sold. 2.5%.
2.5% of MRP. Is it okay if I insert that? Or I put next question?
There's no MRP mentioned here.
Of the sale price. I put it to you, 2.5% of the sale price.
Yes.
I draw your attention to the line in clause 6, which says net sale made. Net, fourth line, net sale made in any part of the world. Does this net sale means net of return of unsold stock by the distributor?
Yes.
I put it to you that this agreement contemplates a physical device being sold for commercial exploitation.
No, I do not agree.
The royalty, I put it to you, is it correct to suggest that film business is a commercial business made for profits? Done for profit, sorry.
I agree.
The cinematograph, I put it to you, the cinematograph film produced, the suit films produced, I put it to you, the suit films were produced for commercial exploitation by way of exhibition to the public at large.
I am not aware.
A cinematograph film is commercialized by showing it to the public against payment of tickets, which is known as box office collection. Tickets, which is referred to box office collection. And please keep in mind the time frame of the films. In the 50s, six.
Let the first answer given. So far as box office is concerned.
In 50s, I assume that theatrical exhibition was only
Answer the first question. The first question is that cinematographic films were shown to public for commercial exploitation by collecting box office, for collection of box office.
Correct.
And the films, I put it to you, the suit films were produced primarily for getting revenue from exhibition in public.
I am not aware.
I put it to you that selling gramophone records of the songs of the film was only additional revenue for the producers.
I am not aware.
In your opinion, as lawyer for a production house, a lawyer.
Why opinion you are asking for? Ask question of fact.
Okay. What is the ratio between revenues generated from exploitation of the cinematograph film and the music?
It's music is generally 10 to 20% of the
total
revenues from a film in the current scenario.
I put it to you that it will not be unfair to suggest that a substantial revenue from exploitation of the film comes from film compared to the music.
In the present scenario, yes.
Do you agree that copyright in original literary and musical works are a bundle of rights as enumerated in clause 14?
Yes.
Do you agree that making of sound recording is one of the many rights conferred by the statute?
Yes.
I put it to you that this agreement in question, Exhibit H, gives right to make gramophone records and to sell it commercially.
No, I do not agree. Under the present agreement, the entire copyright of the sound recording, literary works, musical works came to West in the plaintiff company. West in the plaintiff company, allowing it to exploit the same across any modes and mediums. Any and all modes and mediums.
Mr. Asai, I draw your attention to the proviso of section 6. Clause 6 on page 2 of the agreement. Court's permission, may I read one? Provided that if, I'm just don't take it down, I'm just reading out to the court. Provided that if client shall at any time after the conclusion of the said period of 7 years allow their artists or musicians or any of them to record any works recorded or re-recorded under the provisions of this agreement, or permit recordings of such work from any film soundtrack or recorded tape or other means for any other person, firm, corporation whatsoever, the company shall be no longer bound by this section and shall not have to pay any royalty whatsoever to the client under this section. And I stop here. You can copy and paste it when you... I put it to you that this proviso only gave 7 years of exclusivity to the plaintiff company to make gramophone records.
No, I do not agree. It is only a negative covenant under the contract. It is only a negative covenant under the contract.
I put it to you that the producer could, after expiry of 7 years, commission or grant rights to any third person to make a sound recording in respect of the songs of the film.
It is incorrect to say so.
And I put it to you that in that circumstance, the plaintiff was not obligated to pay royalty when a competing record was made by invoking this proviso.
Sorry, can you repeat the question?
I put to you that in the case that certain case, the plaintiff was not obligated to pay royalty when the competing record was made by invoking its provision.
Yes, this was the penalty under a penalty for contravention of the negative covenant.
Mr. I put it to you, what you call a negative covenant was not an absolute covenant, but a limited covenant, valid only for 7 years. Valid only for 7 years.
Yes.
Did you understand the question? Did you understand the question?
I'm just reading the.
He said yes.
He asked you something.
He said yes, Your Honor.
Yes.
My lord, the witness is nearing 20 years of experience as a lawyer. I put it to you that the rights conferred under this agreement was not perpetual, but only 3 years. 3 years. In terms of clause 12.
No, I do not agree.
I put it to you that under clause 12, if the plaintiff was desirous of continuing the exercise of his rights granted herein, it was obligated to give a notice in writing before the expiration of that 3 years.
This provision does not pertain to.
Answer the question.
I'm answering the question. This provision does not pertain to the tenure of copyright vested in the plaintiff company. However, is a period during which, if any film was produced or released by the producer, the sound recording, literary works, and musical works would come to vest in the plaintiff company in perpetuity. In perpetuity.
Can you explain on what basis do you make this claim?
It's basis this agreement itself.
Which part of the agreement?
The agreement will have to be read as a whole.
I put it to you that reading the agreement as a whole, the rights granted were commercial in nature.
It's incorrect to say so.
I put it to you that reading same sentence, reading the agreement as a whole, the rights were granted to commercialize the copyright in the songs of the film.
The agreement makes no mention whether it is for commercial or non-commercial purpose. Whether the rights granted are for commercial or non-commercial purpose.
The consideration for the grant of rights is contained in clause 6 of the agreement. Is that correct?
It may not be the only consideration. It only provides for making royalty payments.
Can you point out from the agreement what other consideration was there for the producer to execute this document?
There is no mention of any other consideration on the document.
I put it to you that no other consideration was paid to the producer in terms of an advance or a minimum guaranteed royalty.
I do not agree, as I'm not aware.
He may make a coherent statement. Either he's, I don't know.
Let it go. You will
I
explain at
put
the
it
time
to
of
there is no
document.
record maintained by the plaintiff which would indicate that.
You are not arguing. You are just cross-examining.
Yes.
Put all these things in
I
cross-examination.
put it to you, there is no record in the possession and powers of the plaintiff to indicate that any money in advance was paid for the grant of the rights contained in this agreement.
I'm currently not aware.
I put it to you that any royalty to be paid to the producers under this agreement was contingent upon sale of the gramophone record.
Yes, on sale of records.
How long would you take?
Because I'll take time also.
So let it be
Because there are
adjourned.
15 agreements, we have analyzed it. They can be categorized into 4 categories. So I will not repeat all these questions for the remaining of the category, only the variable parts. So this matter, my lords, will
So
take
I'll
some
have to adjourn it today. Today it cannot be
whatever,
paid
my
for.
lords. My lords have accommodated us out of the blue, the roster had changed. My lords may give any dates not so very far away so that we can. My lords, is 6th and 7th of May convenient to the court?
Issue. 22nd?
22nd of May.
22nd April?
That's 2 days consecutive, my lords, be given.
22nd, 23rd.
My lords may have 29th and 30th. I may be held up in Delhi High Court matter.
PW1 is cross-examined in part. Further cross-examination is deferred to 29th April and 30th April consecutively.
My lords may fix it at 2 p.m. So we'll take the morning
2
flight.
p.m. other matters.
Other matters. Okay. And we could take the morning flight and be here at 2 p.m. That's all. First, I will. We'll not insist, my lord. If first half is better, we'll.
All right, I will take it up on that date.
I'm good. On that date. On that.
Obliged, Your Lordship.
One and two.
One and two.
The receiver's report may be filed, my lord. Receiver's report.
Arushila estate matter, my lord. But the
What is the
erstwhile.
Yes. You hand
But-
over the keys and all these things. Have you handed over keys?
No, my lord, not as yet. And my lord, the appeal court had order has in the meantime come out, my lord, dismissing the appeal, and even recording stricture, my lord, in the order.
Look, there is a direction for.
What a day. Only he will take an invective.
This is report of the present receiver.
Present receiver. my
The
lord.
former
May a
receiver-
copy be given to us, my lord?
Former receiver's report may be resolved.
No, but he was removed, my lord.
No, not question of removal.
My-
Handing over keys and all these things.
Yes, my lord, that is due. Still,
Have you handed over documents and keys?
order passed in March.
Please.
Please allow me. Yesterday, my lord, Mr. Gupta came. I said, there is a key upon my case. And there is a record on the door. Mr. Gupta said that it is not my case. Then who has claimed? Myself has not.
Have you any key right now?
No. My key is already there. My key is already there.
Where is your key?
And
where is your key?
This is my key.
Where is your key? Where it is kept?
Accidentally. It is with me.
Hand it over right now.
My lord, I can write over right now. What I want to say that Mr. Gupta denied that it is not my key which has been put on my keys. And the
I can't follow you.
The door is one. The door is one. I tell you. এক সেকেন্ড আমাকে বলতে দিন। The door is one. One door has a key of myself. Upon that key, there is a small key upon my keys. In addition to that, there is a placard on the written there that this is the creation of Mr. Gupta. Who is Mr. Gupta? I asked Mr. Gupta. Mr. Gupta said that it is not my creation. Then who has done it? Myself has not done it. My things and belongings are kept as it is there. I cannot work.
Presently, you are concerned with one key which is kept with you.
My lord, kindly allow the keys to be opened.
That is not your cup of tea. You are removed, you hand over the key only.
My lord, this is need.
Would you hand over the key or not?
I shall immediately.
Do that.
I shall immediately.
Do that.
In that event, I shall be allowed to use the room.
Why?
Because my belongings are there.
Why have you kept it after removal?
Yes, that is the.
Why have you kept your belongings?
And also,
in that case, you hand over the key. If other locks are there, it will be opened in presence of officer of a court.
No, my lord, there is no point. I shall immediately, as per your lordship's direction, I shall give. There is no hesitation.
The erstwhile receiver is present today. The erstwhile receiver, Mr. Ghosh.
Kindly.
will only consider the order to pass the case. He make an inventory of the articles lying inside Malad. That he will do. Going to give him the
Have I finished dictation? Why you are so impatient? Tell me why you are so impatient.
This is sorry, Malad.
Mr. Ghosh candidly admitted that he has one key. However, some belongings of him is inside the room.
All belongings belong to me.
That is not supposed to be. The room in question, Mr. Ghosh shall hand over the key to the present receiver immediately. Full stop. The room will be opened in presence of an officer of this court to be appointed by the learned register original side, not below the rank of assistant register. On
by 12th.
such date and time as may be decided by the present receiver. Full stop. The present receiver as well as the officer of the court so appointed, along with the erstwhile receiver and representatives of the parties, shall be present at that time. A report in this regard shall be filed separately by the present receiver as well as the learned register original side. An inventory shall be prepared after opening the room in question. The reports so mentioned, so directed, shall be filed on or before the returnable date. The matter will appear in the list on 16th May.
My lord, already directed the matter to appear on 6th May, all the matters.
The 6th May? 6th
Yes,
May.
my
All
lord,
right.
there is already.
6th May.
6th May, my lord. Deeply obliged, my lord.
My lord, one thing
And my lord, kindly specify a date for him to hand over. Till date, my lord, 3 months has elapsed.
So it's instant. My order is instant.
Lordship, deeply obliged, my
My lord, kindly record.
I passed order. That's all.
Kindly hear me
Next.
for a moment.
My lord, kindly record. My lord, the report has been filed by the present.
Present
For a moment.
report filed by the present
Because-
receiver. be
Arre,
kept in
Taran.
record.
May a copy be handed over to us? Otherwise, my lord, by the new receiver. By report, my lord,
Copy of the report may be handed over to the parties.
in course of the day.
My lord, my remuneration.
Deeply obliged.
My remuneration has not been.
But see the order of the appeal court. Then. Passed on, my lord, 4th of April.
Come on the next date, then I will see.
My lord, the entire order I am relying on, my lord.
Remuneration has not been paid, my lord, as per your lordship
My lord,
direction.
order was appealed. Yeah, accepted that he has received remuneration.
Come on the next date, I will pay.
My lord,
My remuneration, my lord,
On that date, it will be paid.
on
Next matter.
My lord,
then next day I shall. hand
my lord,
over the
I'm sorry.
keys.
My lord, I am my lord, the applicant in GA 13. The order for inventory was passed in my application. My lord, it may be clarified that even I may be handed over a copy of the report.
Parties, I have mentioned parties. Next matter.
Great.
Next one.
The Kunta dile.
May it please your lordship, my lord, item number 5. My lord, this is an application filed by the joint administrators of Chatterjee International Limited, my lord. My lord, they're seeking for publication of a notice in the newspaper pursuant to orders which have been already passed by this honorable court. My lord, your lordship knows, my lord, with regard to this property of Chatterjee International, my lord, there are certain portions which have already been sold pursuant to orders passed by this honorable court from time to time. And the considerations have been distributed
Was there
amongst...
any order previously to publish
Yes.
notification?
Yes, my lord, there have been. I have an next. Your lordship will kindly then come, my lord. First, my lord, if your lordship kindly sees the prayer at page 15.
What are the previous orders? Previous
I have
orders.
annexed. I have annexed.
আগের order sheet টা দাও। Is it coming for the first time?
This application for the first time.
Well, probably, I'm sorry, my Lordship was talking about a matter which was taken up yesterday. That was relating to sale of a property. But this application is being heard for the first time.
If your Lordship kindly sees the prayer, my Lord, once, my Lord, I suppose it will be easier, my Lord. Page 15 is the prayer.
For the timing only to allow prayer A.
Yes, my Lord. Yes, that would suffice. There has been, my Lord, previously there were orders.
J191 of 2020.
Lord, I appear on behalf of the society. I have not been made a party, but I have been served. Lord, I have no objection if prayer A is passed.
Yes,
After all, Lord, truth will come out.
Lord, I also support not.
J191 of 2024 is passed with various prayers. Mr. Ghosh submitted that for the time being, prayer A may be allowed as the initial stage of hearing. Mr. Sinha appearing for the state.
I'm absolutely supporting defendant. Substitute defendants, Lord.
Appearing for
legal
the
heirs of Mr. Chatterjee.
Substituted defendant and Mr. Dev appear for
CIC Society, my Lord.
CIC Society did not raise an objection. Accordingly, prayer A for the time being is allowed. Prayer A of J191 of 24 be allowed. A draft notice may be submitted before the Learned Register original site for approval. Thereafter, the notice shall be published in one Bengali, one Hindi, and another English daily newspaper widely circulated in the city of Kolkata. The matter will appear in the list on 15th May.
Grateful, my Lord.
15th May, my Lord. 15th May.
It may take some more time, my Lord. If after vacation, if Lordship keeps it, my Lord.
It will take little time, my Lord.
Because publications and all, my Lord.
Lordship makes it 12th June, my Lord. I think that will be.
12th June.
Grateful, my Lord.
May I file the affidavit of service, my Lord?
Affidavit of service be kept in the record.
Deeply obliged, my Lord.
My Lord, I appear on behalf of the plaintiff.
My Lord, I was in reply. On the last occasion, my Lord, we could not proceed with our reply because there was some discrepancy in the written note of the plaintiff. There was some
corrected?
Notes of argument is.
There was no index and there was no pagination.
My Lord, it is ready.
Is it done today? Are you filing it today?
Yes, my Lord.
The copy to the. My Lord, may I consider and come back in 30 minutes? I will just.
Notes of argument.
Yes.
This you have filed today.
Yes.
This your notes of argument.
No. This is their notes of argument which they have just handed over to me.
Okay. Friday, come Friday.
My Lord?
Come Friday.
Friday.
Because second half.
Lordship gives me 10 minutes today anytime. I'll come back. I'll just consider this, just read through this. If there's anything else left, I'll just come back and finish it.
Okay.
You're
Pass over.
Grateful, man. ठीक है, ठीक है.
May it please your Lordship, this is my
Lordship, I am for
substitution
the
application. But if your Lordship kindly takes a look at my application once, now there are several heirs whose death we want to, my Lord, have recorded and also to substitute with their legal heirs in respect of those heirs which whose legal heirs we have come to learn.
Have you filed death certificates? No death
Not
certificates.
for all, my Lord, because we don't have them all. So, my Lord, kindly, and I should also show from their opposition on what grounds they're opposing certain reliefs. May I indicate that? My lord, will kindly come to page
Record
5,
what opposition will you make for recording
Lordship,
date?
Lordship, I'll
So
indicate.
2 years, my lord, they have objection. First,
Only
my lord, they had indicated that they are representing the heirs of defendant number 1C. We had proposed to add 2 sons. They said that the widow is also there. So in the affidavit in reply, we have given a fresh proposed amended plain where we have included the widow as well. That is one opposition. The second opposition is with regard to the legal heirs of my lord Om Prakash Singh, Om Prakash, which is defendant number 1A. We had said that we have come to learn from a criminal proceeding that Shiv Prakash is his legal heir. Though we do not have any document on record, and we do not have any communication
What
from
is
any.
needed is death certificates.
We do not have that.
All right. Do you know what the last place of death, last place of living?
Yes, when we had sought to communicate, the envelope had come back as deceased, and that's how we have
Where
come.
was the last place? What was the last place?
The one which was
Because
given in the
if it is in city of Kolkata, I can pass direction to KMC to issue death certificate in favor of this court or to send death certificate.
Yes. It's within Kolkata.
So you file an application, I will pass direction to Kolkata Municipal Corporation to furnish death certificates. Do you know? Do you not like this proposal?
That can be, but it.
May I indicate one thing,
The
Lordship?
other.
If your Lordship kindly considers this order.
Now tell me, are you aware or do you
Lordship,
admit
we
this?
do not know. On the earlier occasion, my learned friend had
If it is disputed, I won't pass any order.
taken leave to
No,
rely
may I
on a
indicate-
supplementary
may I
affidavit which
indicate
was
to-
not filed.
The issue of dispute, he is not entitled to raise. Why? Because he is only he is representing the other legal.
Even
heirs.
otherwise, I am telling you, Mr. Gupta, without death certificate, I will not pass. I am giving you opportunity to do the needful. If you don't do, I will pass necessary order.
But your lordship will kindly give me a moment, my lord. I shall try and.
Lordship, in their affidavit in reply, they had realized that there was some kind of criminal proceedings from where they have got to know. However, they wanted to rely on a supplementary affidavit which they have failed to file yet.
But if your lordship kindly
The order is here.
takes a look at my application once from where we have derived knowledge of the death.
All right, I will pass necessary order.
But, possibly this factum of death is not disputed. They are disputing.
I will check it. I will pass necessary order.
But, two other things, my lord, which I need to possibly appraise your lordship, my lord, that they are opposing on 2 counts. My lord,
I will
one-
check the record. I will see their opposition and pass
my lord,
necessary
only one thing, your lordship will kindly look at the proposed amended plain annexed to the affidavit in reply and not the application. The reason being, they had indicated in their opposition.
I have heard that. Next matter.
I'm grateful.
But I appear for the plaintiff.
Sir, Lordship, today, Your Lordship, we have already obtained Your Lordship certain orders. Today, Your Lordship is for the passing of Your Lordship consent decree. And Your Lordship, on the last occasion, Your Lordship directed me to produce the original copy of Your Lordship, the terms of settlement. Lordship, kindly, Your Lordship.
That which was corrected. Initially, order was passed. That was correct.
No, that is a different matter. Your Lordship indicated that, but this is a different one. Page 15, Your Lordship, is the
This is the terms of settlement.
Terms of settlement, and decree has to be passed, Your Lordship, on the basis of the terms of settlement itself. Lordship, kindly take page 15 of the page 15 to page, Your Lordship, 55 is the terms of settlement. Your Lordship, kindly take
page 55.
Yes, till page 55. Lordship, kindly take page 53.
This very copy of this one.
Yes, Your Lordship. It starts from page 15. Lordship, kindly take page 53, where Your Lordship, all the parties have signed along with Your Lordship their advocate
What is
concern.
your prayer?
Page 53. My prayer, Your Lordship, today is prayer in terms, orders in terms of prayers G and H.
কোথায় মাসুদ সাহেব? Who is the other side?
My lord, I am for the plaintiff.
Rani and Mr. Tat here was.
Have you any objection?
No, my lord. This has been settled between the parties.
And whoever, Your Lordship, the parties are there, I have included them, Your Lordship, in the
additions are made.
Additions made, deletion made. Whoever, Your Lordship, are not
Not your lordship. They've expired.
Up to F it was allowed.
F allowed. Till F
To
allowed.
F it was allowed.
Yes, yes.
So only G is to be passed.
G and H.
Yes.
GA number 5 of 24 was heard when the prayers were allowed. These prayers were allowed. B to F was allowed.
Yes, your lordship.
A was allowed.
10th January 2024.
That was A.
Yes, A
Then
was allowed.
30th January B to F.
Yes.
Prayer A was allowed earlier on 10 January. And prayers B to F were allowed on 30th January. The parties therein prays for passing order in terms of prayer G and H. Full stop. The original agreement, compromise agreement is filed today. Signed by the parties.
And their respective advocates.
Appearing through their respective counsels.
Yeah.
Let prayer G and H of the master summons be allowed. Decree may be drawn up on the basis of memorandum of settlement dated 29/9/2010, and the same settlement shall be part of the record. Department is directed to draw up the decree accordingly. The suit is disposed of on compromise between the parties.
Lordship, CS also may be suit number 953 of 1987.
Yes.
G as well
The
as
suit is disposed of on compromise
I'm grateful.
along with pending application.
My lord, perhaps just one technicality, my lord. May the terms of the settlement be made part of the decree, my lord.
Yes, that is dictated.
Deeply. Deeply.
The settlement shall be part of the decree, not terms.
Only one line may be added, your lordship. The original terms of settlement be kept on record. Otherwise,
Yes, that is taken.
I'm grateful.
Deeply obliged.
Plaintiff, my lord. The amendment.
आपने आगे मेडिकल में व्यवस्था करो. ना आपने मेडिकल में जाना है. तो नहीं है ओके दिए पता.
My lord, I appear for the plaintiff, my lord. In this suit, my lord, we had taken out an application for amendment of plaint, which was allowed by your lordship, and we were, my lord, directed to serve the amended plaint on Mr. Ghosh's client, which we have done on 8th of March. They were supposed to file, my lord, an additional written statement, my lord, dealing with the, my lord, amended plaint. Now, we have not yet been served with the written statement, but we have been served with an
Firstly,
appeal.
I'm seeking extension of time to file that additional written statement, and also to bring to your lordship's notice, we have preferred an appeal from that order, because our contention was it was barred by limitation. So that appeal we have filed. I was praying your lordship gives us 2 weeks or 3 weeks, just adjourns the matter.
It is submitted by Mr. Ghosh that an appeal is preferred from the order dated.
The last order.
My lord, possibly there is
8th
no
of
recording officer, my lord.
Oh.
My lord, recording officer is not.
21st February 2020.
কি হলো? কবে দিয়েছিল order? 21st February.
The order was passed on 21st of February. I think he was not feeling well.
Oh, he's the one who collapsed that day. Just see. Judicial internship. Clueless. I need to get advocate of the body.
I'm making it not this week.
Very well.
Not this week. No, it's 10 only.
He's not feeling well. I've sent him to medical unit.
Yes.
এখন মামলা কল করবো, আমি ডিকটেশন দেবো কাকে?
Well, in this matter,
কিন্তু কোনোটাই শুনে ডিকটেশন দিতে পারবো না। My problem is I have no air coat today. He has suddenly fallen ill and I have to look for some new one.
as your lordship.
So unless someone come, I cannot give a dictation or pass order.
Well, simple reason, your lordship, the matter is being settled. Well, on the last occasion, I had also indicated that the matter was being settled. Talks of settlement were going on. But your lordship, we have already forwarded a draft terms of settlement to the plaintiff.
Not this week.
I'm grateful, man.
Grateful, lordship.
Who is in 12?
Lordship, I'm okay.
Is it for hearing, Mrs.
Lordship, it is. It is, Lordship. In fact, application was taken up out by the plaintiffs for appointment of.
My problem is that I have no stenographer right now. No court.
My lord, I have no issues. My lord wants to adjourn it. My lord can.
Yes, not this week. Even I have to pass order for not this week only.
My lord, no issues.
Unless someone new has come here, I cannot proceed with the matter.
No, your lordship. Your lordship, the only difficulty is that it has been adjourned for on several occasions.
They at least for this.
No, your lordship, I completely appreciate. Your lordship.
Not this week. Making it not this week.
Your lordship is keeping it on.
Not this week. I cannot pass any order right now.
Okay.
Who will take dictation?
Oh, very well, your lordship.
That is the problem.
So it will be coming up on Monday, my lord. Not this week.
Just check it. Check the.
I shall.
একটু দেখো কাউকে ইয়ে হলো কিনা। আগে আমরা কল করো না, আগে দেখে নাও।
Your lordship.
আমার অসুবিধা নেই, আমিও ফেসে যাব।
16?
Your lordship, can it be on if not 16th, then any day except 17th, your lordship, so that it's not taken up on 17th.
My lord, will it be my lord's pleasure to make it on 19th, my lord?
19th.
Because 18th, my lord, Allah,
19th.
I'm grateful.
Very well, your lordship.
Because 18th, all those bail matters will be lined up there for 20th.
Your matters will please wait.
My lord.
I understand your lordship's predicament because of your May I simply file
Please don't. I have to pass an order then.
Oh, call for it.
Check করো আসছে কিনা। Not this week, only making it next week.
আচ্ছা কি করে অর্ডার থাকে, ফাইলই তো হচ্ছে না। মানে pleadings are not complete in this matter as yet. They are filing their written affidavit in opposition.
Difficult for me to pass any even order.
Yes, your lordship.
That is my difficulty. Only making it not this week, come on the next week.
We will.
At a date দাও।
Not 16. 16. 19.
19 is okay?
Thank you.
What is the progress there?
The inspection of all the properties that could be done has been completed. The writ of commission has also been issued. We are now in the process of just assimilating the data and preparing our report. The only thing that we would require on the next step is the extension for us to file our report.
That will be done. That is known. If the things are in progress, then I will accommodate.
They are much in progress.
All right, come on 19th.
My lord, there was also a direction by your lordship by the order of 19th of February upon the registered original site to furnish the original copy of the decree that was being drawn in 1970. That is
Come
also
on next day.
Yes, your lordship. 19th. 16-17 কলকাতায় থাকবো।
Item 15, 16, 17, 19, 14, I appear for the plaintiff.
Not this week.
My lord, only one thing.
I
my lord.
appear for the defendant,
On
Your
4th,
Lordship.
only I'm not asking for any order, my lord. Only an understanding if can be arrived at between the parties. Only discovery and inspection, my lord. We are at the stage of discovery and inspection. 4th August 2023, we supplied their our affidavit of documents.
These things.
My
Your
lord, let
Lordship,
them
I'm
complete
praying
it
for
by the next
3
day.
weeks' time to file our affidavit of documents.
Next week you will
My lord,
appear.
next week, my lord, whichever date, my lord, takes it up. Let
I am not fixing up right now.
my lord.
Come on next week.
My
16, 17.
15, 16, 17, my lord, not today.
Not this
what?
week.
Yes, not this week.
Not on 15, any day after.
I'm not fixing any date. Not this week.
Deeply.
You follow the list.
Yes.
Deeply.
Not this week. এই উইকে হবে না না হয়ে হলো না আবার নেন পরে হবে এই কি আবার ও আপনার সঙ্গেই তো ও এই তো আমি আছি না না স্পেশাল অফিসার কোথায় আমার
সব পাশাপাশি শুনে নেবো, শুনে নিয়ে দেখছি, ও তো শোনার ব্যাপার আছে।
এটা
18?
Yeah, 18, my lord. This is the my lord. My lord has been pleased to appoint Mr. Tiwari as a special officer. Thereafter, when we communicated, Mr. Tiwari is not inclined to take up now. Your lordship was pleased to direct Mr. Tiwari to appear. Now, today we are lucky that we have Mr. Tiwari in court.
Come on the next week. My lord can.
My lord can hear him that.
My lord, with great humiliation, my lord, I was beseeching my lord, but I would beseech my lord to kindly, my lord, discharge me from the assignment because I won't be, my lord.
Come on the next week.
My lord, let my lord,
Come
my
next
personal
week,
appearance be recorded, my lord.
No.
Aaj stenographer.
Acha. Oh, acha. My lord.
Come on
My
next
lord,
week. Not this week.
No.
Not this week.
Not this week. Also, not week.
You will be unlucky for the second time too, huh?
18? এইটিন কোনটা হলো? 18 হয়নি এখনো। Eighteen is done. 19.
Item number 18, I am for the defendant number 8 in this matter, my lord.
18?
Defendant number 18, item number 8.
Which one? Item number 18?
Item number 18, my lord.
Not this week. 19?
My lord, I appear for... My lord, I appear for the plaintiff in 19. My lord, there was a direction on us to complete the discovery and inspection. My lord, we haven't been able
My
to.
lord,
this week.
No, my lord, I have an objection to this. This is
Not this week.
But this is the 5th extension, my lord.
Come on the next week. I have problems today. 20?
I appear for the my lord plaintiff.
I appear for the defendant number 7.
My lord, the records were not there the last day entirety of it, so lordship had adjourned it, my lord, and kept it, my lord. But if lordship has, my lord, difficulty today, we can come back, my lord.
Yes.
My lord, instead of Monday, my lord, next week would be Monday, my lord. I have some personal difficulty. Can it be on Tuesday?
20. 22. 22.
22.
Grateful, Lordship.
This is my suit against the official liquidator.
Miss Dasde is appearing for the official liquidation.
Not this week. Making not this week. I have some difficulty today.
So, because there's consent decree, there's no defense. So,
come on the next week.
Then kindly make it the week after. Next week, I have some matters fixed.
22?
Yes.
My lord, in 22, my lord, I am for the plaintiff. My lord, I had offered inspection yesterday, my lord, which has been refused to be taken.
Not this week.
Lordship, I appear for the plaintiffs. Lordship, there was an application that we had taken out for directing the valuer to file a fresh report considering certain discrepancies. Lordship, the affidavits are complete in the matter.
Next
on
week.
the last.
Come on the next week.
Lordship.
May it please, my lord, I appear for the decree holder. My lord, there is just one indulgence, my lord. I need to file my affidavit to his application, my lord. So, my lord, if my lord keeps it 1 week hence, my lord, I shall come up with my affidavit.
Not
my,
this week.
Not
my
this week.
application is for your lordship the taking out an exception,
Exception
of
to the special officer's
special
report.
officer, special referee's
week.
report, your lordship.
I'm grateful, my lord.
6, 7.
My lord, may kindly keeps it 2 weeks hence. If
Date देके दिए दियो.
Otherwise, again, your lordship, they'll come and pay for
yes,
time.
my
and
lord. If
spend
my
it.
lord keeps item number 24 2 weeks.
May te दिए दाओ date.
Mete.
Mete diye.
কত মে দিচ্ছি?
6 and 7.
My lord.
Item number 6 and
Where is Mr. Bosch?
My lord, since my lord is adjourning the matters because of
Keeps the matter after
20th.
any day after.
Mr. Bosch is supposed to come. Would you communicate?
my lord, the junior is here, my lord.
He's on legs, your lordship.
That's why I said you adjourn today.
Very well, your lordship.
Any
Your lord
Keeps it any day.
any day after 20th, your lordship.
Any day.
25. देखा ना? 26.
26.
Adjourn to 26. Today, because a certain difficulty came up.
No, very well, your lordship. Grateful.
Yes.
না হবে না স্টেনও নেই ভোট ফাইল করে তো অর্ডার দিতে হবে ওই জন্য সব লাইন দিয়ে ছেড়ে ধরে
Item number 1.
Yes. ডিফল্ট হয়ে গেছে
Item number 2. Item number 4.
But I am for the petitioners. There is no correction. My Lordship, kindly sees the last order.
Necessary correction may be made in the cause title of the order dated 10/8/22. Since by changing the year number, by changing the year to 2022.
Yes.
Substituting 2012.
Would your Lordship please to hear this matter someday?
No, only correction.
Only for correction. I'm obliged.
I have no determination.
My Lord, I'm deeply obliged.
Happily, I have no determination.
My Lord, this is a revisional application. Criminal.
This is for correction only.
Obliged.
Mr. Lahiri is releasing it, pending for long. I have no determination, so I am releasing it.
It has been specifically assigned to your Lordship. Possibly an assignment.
Assigned to me.
Probably it was assigned to your Lordship.
Possibly.
Initially, the matter was probably taken up by my Lord Justice Iptankar Kor. His Lordship released this matter on the personal ground. Thereafter, probably this matter could have been assigned.
Then I should fix a date if it is so specially assigned for finishing it.
In any case, my lord, in February 2023, it was part heard by your lordship. Substantial submissions have been made by Mr.
When you will
Rai.
come, I will fix consecutive dates.
As your lordship convenience, when your lordship can.
এই মাসের মাঝামাঝি
Fixing it on 29th. The matter shall appear in the list on 29th April. 29 to आगे करो तो.
My lord, may your lordship be pleased to take it up sometime in May, my lord, because if your lordship fixes 1-2 dates consecutively, my lord, 29th would be a
Or short dates, let the first appear on 29th. 29th April at 2 p.m. Finish it. Don't keep it pending. Yes, sir. How are you?
Fine, thank you, man. My lordship has aged a little. Aged a little. Hairstyle has
That
changed.
should be. That should be.
That's with the chair, no? That comes with the chair. Hey, এটা কি aside না পাঠার দেখো তো? Aside. Well, it keeps a date, well, because the other side, I don't see anybody for the Provident Fund. Mr. Prasad is there, man. Keeps a short date, man, or keeps it on the 29th as your lordship is keeping that. Because my lord is going to sit for the appeal. And this is a matter, my lord, where in your lordship is
First May at 2 p.m.
Grateful, my lord. First May.
At 2 p.m. Who is the other side? State.
Well, I'll know Mr. Prasad for the Provident Fund. I'll give him a notice, man. Grateful, man. Yeah, very good.
First May গুলো লিখে রাখতে হবে মানুষকে একটু বলে দিতে হবে মানুষ আছে এখানে ঠিক আছে কোনটা না মনে থাকবে মানুষকেই বলছি লিখে নিতে হয়ে গেল তো ওই পরেরটা আর দুটোই তো বললাম First May. দুটোর সময় একটা ক্রিমিনাল অ্যাপিল আছে নোট করে রাখছি ফার্স্ট মে দুটো ক্রিমিনাল অ্যাপিল এটা নিয়ে নাও
I have for the plaintiff.
You have paid for traveling cost that I have not allowed.
Lordship.
Otherwise, it is allowed.
I'm grateful, Lordship.
Because traveling cost is not part of profit. Take it in the website. I'm grateful. Suit is dismissed.
ডাক্তার দেখিয়েছিল? ডাক্তার দেখিয়েছিল? কি বললো?
For the plaintiff, Miss A was making her submissions. Perhaps she is stuck somewhere, my lord. I don't see her. Yes, my lord. She was to finish her submission on the
And
issue
I
of
told her specifically to go through the judgment of Money Square. Money Square's judgment. Then?
Well, it keeps another day because I have to normally they are Mr. Ghosh and Miss they are in reply, but Mr. Ghosh has cited two judgments which I may need to meet. But whether what she will submit, my lord, further I don't know.
16 is okay? Tell her.
And my lord, she is here.
No, I'm very sorry.
16 is okay?
Oh, we are adjourning. Oh, sorry.
Would you submit?
It was for me to conclude or.
If you're ready, I can hear you.
I am ready. Subject to your lordship
No,
permitting.
no, it's okay.
But I have prepared a note. The states, is the argument is just twofold. One limitation, which I have, already submitted before also, and on the last occasion also, that the suit for declaration and eviction today is barred. I have shown the documents, and I have relied
On vesting.
on limitation. I have shown now vesting.
Vesting,
What
yes.
fell from your lordship is vesting. That I have to show whether it has vested or not. My answer to that is, if it has fallen from your lordship, I must satisfy. And I must show that there are kacha structures. The evidence before your lordship, contains references to kacha structures only. There is no question put to any of the witnesses in examination or cross-examination wherefrom it has revealed that there was at any point, pakka structures. Money Square now till 2010, I must show kacha structures. Evidence is there were kacha structures. Plus, additionally, ground rent, provisional ground rent, was paid to the state from January 1982. So, the status of the defendant number 3 was never disputed, as a Thika tenant. These are, my lord, the factors. Also, my lord, there were structures which the defendant number purchased from one Vijay Timbers, my lord. That is, my lord, sometime before the first lease came into operation, from 51 onwards. That is also in evidence that these structures, my lord, was procured by the defendant number 3. Now, this, my lord, I'll show. But my fundamental argument would be, my lord, that the moment, this is a suit for declaration, my lord, prima facie, this is maintainable. But the moment, my lord, an issue arises upon defense, whether the structures are kacha or not, whether he is a thika tenant or not, my lord, then section 21 of the 2001 Act, my lord, comes into operation today. Today, that is, my lord, the act which is operational, which, my lord, ousts the jurisdiction of this court, my lord, to enter into this issue. That is, we have a specific ouster clause. This was there in the 1981 Act also, section 23. Now, my lord, 2001 Act also, this is still incorporated. Now, I'll show, my lord, in another matter of our High Court only, when the declaration suit, permanent injunction, the court said the moment this issue arises, I have to stay my hands off and I cannot enter into this. This is, my lord, in a revision that this court had held that. And the suit was...
Come with a short note of argument.
I'll show that.
Short note of argument.
I have. But, my lord, this, since it
On this
felt-
point, on this particular point.
Yes. On this point I have, I'll also...
Because your notes of argument is basically on declaration, limitation and all these things.
I'll also incorporate this now.
Yes.
I'm just laying out these facts, my lord, the points. One is that...
One is there was such a structure. So Pani Square judgment will not apply according to you.
Yes, also, my lord, Money Square will not apply because that was an appeal from the controller. When the moment I say, my lord, this court does not have jurisdiction, that point Money Square, my lord, does not decide. It was not, my lord, an appeal from a declaration.
Pani
injunction.
Square decided what is best, what will not.
Yes.
This much, not from this court or that court.
He did not. So
That cannot be that cannot be by any way, the meaning cannot be stretched to
yes,
that extent.
I'm grateful.
Money Square is very clear. If it is pakka structure and for commercial purpose, there would be no vesting.
No vesting.
Irrespective of appeal, revision or whatever that might be. Forum is not an issue.
Yes, but my lord, yes, I bow down. But here forum is an issue, my lord, because today your lordship is deciding this question in a declaration suit. And my lord, my submission before your lordship is that this is not the forum to entertain this question. My lord will once kindly take that section 21, my lord, of the 2001 Act
Anything arising out of Ticket Tenancy Act.
goes out. No, there is
When this court is deciding, you explain this point, clarify this point. Court is deciding also whether the plaintiff has any locus standi to file eviction petition. So that decision is necessary. If there is vesting, plaintiff has no locus standi. On that ground, suit will be rejected or dismissed. That's why incidental finding is also needed. You clarify that.
Incidental finding, my lord, subject to correction, my lord. This court cannot. I understand what your lordship is saying. That today, my lord, he wants to file an eviction suit, my lord. How can this court not entertain that? My lord, that the court will not be able to entertain it the moment a defense is raised that this is a thika tenancy. Under the original act, my lord, the suit was maintainable in court. Under the 1949 Act, where the issue of vesting was not there, a civil suit, my lord, under the statute was specifically maintainable. But from 81 onwards, my lord, that has gone. That is not there anymore. My lord, kindly, my lord, may I perhaps, my lord, the point will be more clear. Kindly, if your lordship sees the language of the ouster clause once. This is
Yes, I've seen that.
section 21. I am not on 5.3. I am on section 21. Bar to jurisdiction. And this clause, my lord, in the Recovery of Debts Act, in Waqf Property Act, everywhere, if there is a bar to jurisdiction, civil court, my lord, cannot entertain the issue. Not section...
You are referring to section
21
of 2001 Act.
2001 Act.
Why 2001 Act will apply?
Because that the earlier act is...
When the suit was instituted, what was the prevailing law?
81, but
Then?
today, I'll show that also. Well, let's come to that. That is section 23 in the 81. But today, my lord, when your lordship is deciding today, the law today will be applied. And the 81 Act, my lord, stands repealed. But my lord, I'll still show that. In that section 23 in the 81 Act. Act, my lord, section 23. Bar to jurisdiction. Has your lordship got that, my lord?
Yes.
No civil court shall have jurisdiction to decide or deal with any question or to determine any matter which is by or under this act required to be or has been decided or dealt with or is to be determined or has been determined by the controller or the appellate authority or other authority specified in the provision of the act, and no order or judgment passed or proceedings including execution comments shall be called in question in any civil suit. Now, this act is now repealed. This kindly takes now section 21 of the 2001 Act. And my lord will read that with section 5(3). Section 21 of the 2001 Act.
Yes.
No civil court shall have jurisdiction to decide or deal with any question or to determine any matter which by or under this act is required to be decided or dealt with or which has been decided or dealt with by the controller. Now,
What is in 1981 Act?
Lord,
What is in 1981 Act?
1981 Act, section 23. Same. The language is same.
1981.
Yes, 81 section 23, which is by or are required to be determined by the controller.
Yeah.
No order or judgment or proceeding. Today, my lord, your lordship, perhaps, my lord, can't follow the 81 Act, my lord, because this repeal 2001 Act has been given retrospective effect from the date of the
So according to you, 21 bars jurisdiction on this court.
read with 5(3). Kindly see 5(3). 5(3) is important because everything can't go to the whatever the controller has jurisdiction, only that goes. Section 5, subsection 3. If any question arises as to whether a person is a thika tenant or not, or whether the land in question is
Controller will decide the issue.
Controller will. So today, my lord, I say if this issue has come before your lordship, then my lord, that issue cannot be gone into by this court. And this, my lord, has been confirmed in a revision, my lord, where a similar situation arose in a declaration, my lord, suit. Where the tenant has made a declaration saying, I should not be evicted, give me a declaration to my possession. Court said, no, nothing doing. This as civil court has no jurisdiction. Similarly, in my lord, Recovery of Debts Act, when my lord, the borrower files a suit for damages, my lord, against the bank, court said, no. There is a specific ouster clause of section 34 in the RDTB Act. This question, every question, you have to go before the controller. Also, my lord, Wakaf property, I have, my lord. Some person says, I have purchased this property, so I want declaration of title. But the court said, my lord, division bench of our High Court, that the moment an issue arises, whether this is Wakaf property or not Wakaf property, this court will not, my lord, enter into this.
Please go outside.
Without into judgment now, that So, my lord, on this point, your lordship, my lord, when the matter was initially going on, your lordship said that this point I am not letting you argue now, but if it comes later on, you will. And this is the law, my lord. It is my duty to bring it before your lordship. This is kindly see, my lord. My lord will kindly take.
Come with compilation. Come with notes of argument and compilation of judgments.
Citations are given. I can also come ready with.
You take the citation, but you come with the compilation.
I'll come
with all
with the
judgments
compilation
and refer to Dula Bhai's case.
Yes. And Milo, sorry, what?
Dula Bhai said the ouster of jurisdiction.
Oh yes, cannot be inferred. And
readily inferred.
Cannot be readily inferred. But it does not say that when specific, it says.
You argue that.
Yes.
That will be your argument.
Recently, 2009. I have 69 is Dulabhai. দেখাচ্ছি Milord, so this forum Milord ouster clause Milord, this is my crux of my argument Milord, plank of the argument is this, that today, and Milord, if my learned friend plaintiff today say Milord this is not decided here, how is he aggrieved? Today Milord, the controller Milord will decide whether this person is a Thika tenant or not. There is a provisional assessment already done. Ground rent in terms of the rules Milord are being paid to the Thika controller Milord since 1982. If it is determined today he is a Thika tenant, and my learned friend then is entitled to compensation Milord, whatever under the law, and that also Milord will be by the state authorities, whatever is available to him. So he is not prejudiced if the suit goes, and suit has to be decided on what the law is today. When a decree is passed Milord, it has to be. And my learned friend has said that on an earlier occasion, at a different earlier stage, this point had come in the nature of an Order 7, Rule 11, where Milord, we lost. But the division bench has Milord retained my right to argue this point. So today my learned friend cannot contend that this point Milord cannot be.
I did not contend that.
You are not so very well.
Cited those, wrote those judgments only to say that this was held earlier, and I am making the same arguments before my court of that particular.
Come with the notes of argument next day. I will hear Mr. Ganguly on.
First Milord, I will satisfy your lordship Milord on forum, and after that Milord.
Notes of argument.
Give a notes of argument. I have heard your argument.
Very good.
Whether this argument will be accepted or not, that I will decide after consulting all these arguments, counter arguments. So that will be reflected in the judgment itself.
But
Once you will file the notes of argument, I will keep it for consideration.
Very well. And also I show Milord from the questions where Milord kacha structure etc. Milord has been
Mention that.
I have mentioned that. And there is also a special officer's report pursuant to Milord an order of court.
Do one thing, prepare a notes of argument and compilation of judgments. Come on the next day. If you want to make further argument, I will hear you. 16th.
The citations may be, copies of the judgments may be given to.
I don't need the copies, but
What is citation?
16th. 16th is okay.
16th. Yes, Milord.
Heard in part adjourned to 16th April.
After they will not conclude, I shall submit the notes of argument.
So that none can see it. So that none can see it.
I have a implicit, when Mr. goes on the other side and with they on the other side, I have implicit faith on them that they will not include anything which has not been done.
And also one thing I must say, Milord, from the notes of the plaintiff, my learned friend has not dealt with the point of limitation at all. I couldn't find.
I think I have.
There is nothing.
I think I have. I think I have.
As it may be.
Answer to limitation.
Obviously, I have answered.
As it may be.
Specifically, my lord, in the second supplementary note is there. It was handed over.
Place all your notes of argument on all these things. I will decide then. I cannot say whether I'm convinced or not.
That is the problem. Milord, that is when I need to know how far I should argue to convince.
You argued to the best of your limit.
This is my
You have argued. Now I have to think over. Several judgments are there. Lot of judgments are there. Yes, no on both sides. That I have to consider. I have to go through the whole factum of the case. Evidences. Then I have to decide.
We can only assist, my lord. Whether we can.
I cannot readily say, yes, you are right. Because after hearing you, I have to go through the record. I have to check the evidence. I have to check all these things.
I will mention then everything
Yes.
elaborately. In my
Yes, factual details. Law is not applied in abstract.
Absolutely.
You must have to mention the facts, evidences.
But may I also prepare a page dealing?
As you like it. I have no objection. And don't run away from here now. Another is here.
Next matter.
Yes.
এই সূর্য দাও।
দিচ্ছি আমি এখান থেকে সরিয়ে দিচ্ছি
Yes, Mr.
Still next. আপনার চলবে তাহলে আমি চলে যাই।
ঠিক আছে, আমি পরে শুনে নিচ্ছি। Yes.
May I resume, Lordship? I had finished on defend number 1. I had given my notes on defend number 1. Now, my lord, I am going on the other defendants. This is the second part of my note I shall be placing. This is the other defendants who have defend number 1 had got possession from me. That's admitted possession. Now, Lordship, may I place the first paragraph? Written statements have been filed only by defend numbers 8, 10, and 11, apart from 1. And accordingly, their cases will be dealt with hereinafter separately. So far as defend number 2 is concerned, they are the original lessee of the property under the Maliks, under the registered deed of lease of 6th May 1960, which is for the period up to 2034. The defend number 2 is not claiming to be in possession of any part of the property. There is no claim against defend number 2. The lease is in respect to the land with right to develop that was given to defend number 2. The lease is still subsisting and there is no pleading or evidence to the contrary. Now, so far as defend number 8 is concerned, what is their case? Case has made out by the written statement, evidence analyzed the form of a list of dates. 24th March 81, this is a bit of a repetition because that's in my earlier notes also. Registered agreement for sale of the suit property was entered into by the defend number 2 as vendor, like lessee cum developer, in favor of Shonchoita Investments with right of nomination. Shonchoita, by a registered instrument, this is 21st April 82, as original purchaser, that's how it is described, by registered agreement, nominated the plaintiff to acquire the suit property in terms of the agreement of 24th March 81. Then 12th May 82, the defendant number 2 in writing accepts the plaintiff as owner of the suit property and also confirms delivery of possession to the plaintiff. I'll place the documents shortly. Then 4th May 93 and 27th September 1983, Supreme Court appointed commissioner over Shonchoita and vested him with power to attach properties of Shonchoita. The commissioner of Shonchoita Investment, in exercise of such power, had attached the suit property. Please see the narration of facts in the order of 4th July 85. On 4th July 85, order of the Calcutta High Court Division Bench, that's the Onilshan Division Bench, this order records the attachment to the suit property by the commissioner and the objection thereto filed by the plaintiff as independent owner thereof by transfer. That the plaintiff has paid rupees 12 lakhs, order records, to the commissioner for release of the suit property from attachment. The court releases the suit property from attachment. This is the... Now comes 15th March 88. After we let defend number 1 enter the property, use the property as a bare licensee. 15 March 88, defendant number 1 allegedly by a letter assigned 2060 square feet super built up area to one Kiran Arya. Mita Aryas, Renu Singhal and Santosh Singhal singles by letter. Evidence. This document has not been exhibited and merely marked for identification. The note in this letter, this is not exhibited, the defendant number 1 has claimed to have acquired title to the said 2060 square feet built up area and promised to execute a stamped and registered instrument if desired by defendant number 8. Thus, no title passes. By letter title does. Firstly, the D1 had no title. Secondly, D1 by letter can't transfer property. Then 3rd August 1990, by an alleged
According
agreement.
to you, defendant number 8 is neither sub-leasee 2. Because at base, defendant number 2 was a leasee. So, out of that.
Well, defendant number 1. Defendant number 1 at best is the lessee.
Lessee. So, he could sublease the property only.
That's all. Now, but defendant number 1's case is that they have just transferred to defendant number 8. And that defendant number 8's case also, I mean, not directly, but first to the Aryas and Singles, 15 March 88, by a letter. Then comes also 3rd August 90, is Aryas and Singles by an alleged agreement, unsigned, unstamped agreement, not exhibited, transfers it to one.
So, even not a sublease was created.
To Deklapara. Then, thereafter, this is also unstamped, unregistered. Then in 96, then 95, Deklapara transfers to one Bengal Tanning. That's also an unregistered, unstamped agreement. Again, not exhibited.
So, subsequent transfer, all are unstamped.
All unstamped, all unregistered.
So, no lease was created in that sense.
A bare licensee transfers his ownership.
According to you.
That is a pleading I will just now place, my lord. And that way it ultimately comes rolling to the defendant
number 8.
The 17th July 96 to Bengal Tannery. Now comes the Bengal Tanning. Now a new turn takes place. You kindly come to the date of 7th September
So,
96.
number of transfers, so-called transfers, ultimately it came to defendant number 8 on.
No, but yes, to the defendant number 8. That is 17 July 96.
96.
Bengal Tanning Industries transfers to the defendant number 8.
Starting from 15/3/88.
Starting from 15/3/88, yes. Comes to 17/7/96. D8 gets it. All unregistered, unstamped, either unexhibited or something subject to objection. I will ask for impounding the one which has gone in. Now, then comes the interesting turn. Again comes to this date, page 5, 7th September 96. An alleged deed of conveyance from one Bijon Bihari Ballik to the defendant number 8, purporting to transfer the said 2060 square feet for rupees 4,12,000. Whose Bijon Bihari Malik is supposedly the owner of the property, under whom defendant number 2 became a lessee with right to develop. Defendant number 2 then transfers to Shonchoita, attached. And then from Shonchoita, I get possession by another registered instrument, order of court. And possession made over by defendant number 2 personally. By a letter, defendant number 2 makes over possession to the plaintiff. Handing over possession from defendant number 2 to the plaintiff. Then suddenly comes 7th September 96, there is a registered deed of conveyance from defendant number, from Malik's to the defendant number 8. I have submissions to make on that. Kindly come to 7th September 96 for 4,12,000. Kindly see my note. First, this case of the defendant number 8 acquiring title from Malik's is not pleaded in the WS. I'll place the WS.
Their owners, they claim their owners.
Mallik's claim to be owners, and defendant number 8, after getting all these assignments, also gets a conveyance deed registered from Mallik's to defendant number 8.
So they claim to be owner. They claim that they derived the title from the Malliks. So in
No,
their
but then at the same time, the defendant number 8 also, defendant number 8 pleads that it has acquired his title from D1, my licensee. Most importantly, that he has acquired ownership from Mallik's by this conveyance is nowhere pleaded. In the written statement, the defendant number 8 claims its right only through those 4 unregistered, unstamped documents from D1. Licensee transfers to somebody else.
Number 8 only relied upon this unregistered instrument.
Unregistered
To
instrument.
trace his title.
Now, at the time of evidence, they adduce by way of an evidence this registered conveyance deed. So, but I shall be making 6 points apropos this document. My first point is the simplest and the most sacrosanct and established point. No pleading, no evidence.
Evidence cannot be beyond pleading.
There is no pleading when D8 had itself set up its title, having been acquired from D1 through 4 sets of unregistered instruments. This new form of title, which is a question of fact also. Title is a question of fact. Mallik's, as allegedly owners, transfers it to defendant number 8. It's nowhere pleaded. It's contrary. In fact, I will say this is contrary to their pleading. If I say I have acquired the property of the Dhruva Ghosh, then in that case, in evidence, I cannot say I have acquired the property from Mr. Arifan. I have to stick to my pleadings.
And you cannot adduce evidence.
So, my first point is that, and I will cite a few standard judgments. My second point is, defendant number 2 having accepted the plaintiff as the owner, because this I am showing on the basis of the letter written by defendant number 2 as lessee to me, would not have purported to transfer the property to anyone else. So, Mallik's defendant number 2 is the confirming party. Just see the Mallik's deed. Then otherwise this is not required. You just see. Then my next point is, as a photocopy and without any evidence under section 65, this document is inadmissible because they don't give the registered deed of conveyance. This document purports to record that the lease in favor of D2 has been terminated. It's very important because defendant number 8 has given the property. Well, then Lordship kindly give me 1 minute. Come back. Yes. Then 3. This document purports to record the lease to defendant number 2 has been terminated. D8, sorry, defendant number 2, original lessee and come developer of the property from Mallik's, from this Bijon Bihari Mallik's predecessor, supposedly. Supposedly, Bijon Bihari Mallik is the successor in interest. When the lease is given to the lessee with right to develop and lease is subsisting, determination of lease can only be accordance with law. Either a decree coupled with execution and recovery of possession, or surrender by an appropriate instrument and handing over of possession by the lessee to the owner. Only then can the owner deal with the property. Owner on its own can't say in a unilateral document that I have terminated the lease of 99 years and I have become the absolute owner and I am transferring the property to you. The lease can't be ignored by the lessor without the termination happening. If at all any right could have been created, it will be subservient to the existing lease, to D2, which has been transferred to me. Now, my lord, next flaw is in this deed also of 1996 from Malliks to the defend number 8, Malliks have accepted the defend number 2 as a lessee. And thereafter has said defendant number 2's title passed to arrears and singles. No instrument of transfer. Arrears and singles to Dheklapara, nothing. Dheklapara to Bengal Tannery. And Bengal Tannery to D8. Last deed, if it is, even if it's registered, the chain is not there. So Mallik is also apparently treating the defend number 8 as having acquired his right from D1 through those 4 unregistered instruments and confirming that right. So this chain is broken. There is no chain at all. This chain of 4 unregistered deeds can't pass a title. So can't confirm a title to somebody who himself has no title. That's my next point. Then the point after that is, apart from the defend number 2's letter of 12th May 93, 12th May 83, in the absence of the defendant number 2's lawful determination of lease and restoration of possession by D2 to the Malliks cannot create any right in the property unto persons deriving their right directly or indirectly from the lessee. Because after all, D2 gives it to the plaintiff through Sean Choita. Through plaintiff comes D1 as a bare license. D1 or his successors in interest cannot claim a right better than the source, so that is plaintiff, and cannot acquire a right directly from the original owner. I will cite those judgments in the proposition on estoppel that a sublessee, if the sublessee acquires a...
After finishing your argument, you come with a consolidated notes of argument.
Yes,
These are piecemeal. Come with a consolidated note.
Yes, of course. That I shall, last day, I shall consolidate my 3 notes and I shall summarize in place.
Summarize and file 1 notes of argument.
I will.
So I will ignore all these notes of argument at that time, finally, and that notes of argument will be relied upon and looked into only.
Fine. So there, for the last proposition, I rely upon those judgments where the sublessee resists the eviction suit filed by the lesser sublessee by saying that I have acquired my title from the superior landlord, the owner. When the lessee seeks to evict his sublessee cannot set up a title through head lesser. Because head lesser can't pass a title to sublessee without first eliminating the right of the
Come on the next step. This is different number 8.
Other 2 I'll also add it and I'll make my consolidated note and come, because the other 2 really flows from the same as the...
Come with the notes of argument.
I will make one consolidated.
Mitro in part. Are Mr. Mitro the learned counsel for the plaintiff in part? Fix. 26. 16 is okay? 16 is okay. 16th April for further argument or some more date, later date.
Grateful.
Or some later date.
16. Then Lordship kindly keep it. I will consolidate the 3 notes. Lordship kindly keep it. Lordship then I would say if it's possible on
first week of May.
On 19th, I want to finish it off. If it could be on 18th or 19th instead of 16th, because then I can complete.
19th.
দুটোর থেকে
আর দুটোর থেকে
19th I'm in something. 18th,
এটাও কিন্তু
18th or 18th, well,
No, not 18th will not be possible.
22nd. Then 22nd, if you come in.
22nd?
I'm grateful to her.
Mr. Mitro is leading me at 2 o'clock on 9th.
But I'm giving this priority.
I will need him there.
Just a minute. You check one judgment. You check one judgment.
Yes, my lord. For the previous, the other matter, Bothra.
এটা দিয়ে দাও তো। I have not seen it as yet. I have to check it. I have not gone through this judgment. Yes.
Well, on the last occasion, I placed before your lordship the plaint and the issues framed in the present. My lord, before going into the facts and referring to the exhibits, etc., I just draw your lordship's kind attention to the issues framed again. There are two orders. First one is dated 29 March 2023. And the second one is dated 26 April 2023.
March. Why the another date was issues were changed?
One additional issue was
Pecuniary jurisdiction.
yes.
Cause of action, maintainability, then
Then may I
106.
just point out to your lordship from the first order dated 29 March. May I go to the root of the matter, if I may say so? Kindly come to issue number 4.
Whether determination or termination.
Termination of tenancy of the defendant is valid and proper. Second one, what is the status of the defendant at present? And my lord, 6, whether the
Liable to be
defendant is
affected.
liable to be. That is the crux of the matter. The other issues are there, but it will follow the answer to this issue.
What is
And
your status and whether you can be evicted or not?
in fact, the issue number 6 will cover all aspects. And my lord, issue number 1A is the
Pecuniary.
pecuniary jurisdiction. Now, just to
For the
recap,
time being, that can be ignored. That can be ignored for the time being.
yes, I shall go to the facts. The please keep ready the brief of document. আছে সব কটা আছে তো? Brief of documents exhibit.
Judge's brief of document. Thou?
Now, kindly, just to recapitulate, I shall go to the facts chronologically. What are the allegations made in the plaint? Kindly have a look at the plaint first, printed. The suit was filed on 9 December 2003. I find it from the writ of summons.
9 December.
Presented on 9 December 2003.
Yes.
And plaint filed on 9 December 2000.
Presented and admitted.
Kindly come, my lord. Just to recapitulate you a few averments, paragraph 3 of the plaint. By and under an agreement dated October 29, 1973, the society, being the landlord of premises number so and so, let out the entire 9th floor of the said premises in favor of the defendant above named. The said agreement dated 29th October 1973 created a monthly tenancy in favor of the defendant in respect of the entire 9th floor measuring 7350 square feet at a monthly rent, after a few lines, of 11,025 to the society. Subsequently, the defendant was paying such monthly rent together with property tax of such and such, aggregating to, kindly note, rupees 12789.26 per month. Now, paragraph 4, they filed the earlier suit, ejectment suit, in the London City Civil Court at Calcutta after serving a notice under 13(6). And on the application of the plaintiff, the said suit was dismissed by order number 89 of 8 April 2003. Then paragraph 5. In the withdrawal application, the society categorically stated that the plaintiff in the said suit did not want to proceed with the suit under the West Bengal Premises Tenancy Act. The defendant thereafter paid rent to the society at the old rate for the months of April to August 2003. From the evidence on record, particularly the orders made in the London City Civil Court and suit and by the dishonorable court in several proceedings arising out from there, it will transfer that we have deposited the rent for the entire period. So, up to August 2003, as on today, on the analysis of evidence, I shall place the evidence chronologically. Up to August 2003, there was no arrear of rent.
When tenancy was terminated?
This paragraph 6 is the next paragraph.
End of month of August 2003.
3.
That is 1st September.
First, with effect from 1st September. 5th July 2003. This was the 106 notice. Then paragraph 8 is very important. The defendant has been in possession of the said premises from 1st September 2003 as a trespasser, and the plaintiff number 1 is entitled to vacant and peaceful possession of the demised premises. So, on the basis of the allegations made in the plaint, usually in an eviction suit, The claim is for decree for eviction, arrears of rent if any, and claim for mean profit. Here, there is a gap from 1st September 2003 and suit was filed on 9 December 2003.
So your argument to us, this security deposit is applied for these 3 months period. So there was renewal of tenancy. And on 116, they consented by retaining the amount.
Retaining the amount. And secondly, in any event, we deposited the entire amount under the order of London City Civil Court at Calcutta. They did not prefer any appeal therefrom or made any other application to go higher up.
So lastly, you argued that since that is adjusted, there was no termination of tenancy, or rather tenancy was renewed.
Renewed. Hardly, subsequently, they by letter asked for the rent of a period, including that period also.
After termination.
After filing of the present suit.
That means after termination.
After termination. So security deposit is treating the tenancy as continuing, one aspect.
That means retaining of security deposit.
I'm sorry, retaining of security deposit by the landlord. Second aspect is the rents for the 3 months, September, October, November 2003, and a part of December 2003. For that, I have got 2 limbs of my submission. First one, we have actually deposited the amount for the entire period, including that period. Because other period I'm not concerned. We are concerned about the 1st September 2003 to the institution of the present suit. Day before the institution of the present suit. And after filing of this suit, the the plaintiff through their advocate has asked for the rent for the period after September 2003, including that period. So these two factors or facts clubbed together clearly show that the plaintiff has treated the amount paid by the defendant as a rent.
That means there is a renewal of tenancy.
Renewal. In whatever way we look at it.
And as such, there is no cause of action, or the cause of action is abandoned.
Notice goes.
So there is no cause of action.
No cause of action. So may I now, keeping this in mind, and my lord, one aspect is pecuniary jurisdiction. I shall place the judgments because the basis, I'm sorry, my lord, the basis of their claim on merit and, my lord, on the pecuniary jurisdiction is their pleading in paragraph 8 that on and from 1st September 2003, I am a trespasser. Paragraph 8.
Suit is valued on the basis of mean profit.
Pleading is, that's why I segregated eviction decree, arrears of rent, and mean profit. These are 3 aspects. Kindly go to the prior relief claim. Prior A, decree for eviction. Prior B, as pleaded in paragraph 10. Paragraph 10 is calculation of mean profit.
C is the interest.
With interest, of course.
D.
Then decree for mean profit, such and such, etc. etc.
So suit is valued on the basis of mean profit,
Mean profit,
not on annual rent.
not on annual rate.
That's why pecuniary jurisdiction is questioned.
I should add one further rider to this. The plaintiff has not claimed any arrears of rent, and they have not valued the suit in accordance with section 713D of the Court Fees Act. That is one aspect. Secondly, their claim in the present suit is on the basis that I am a trespasser, or I became a trespasser with effect from 1st September 2003. This is very important. If I can show that I am not a trespasser, then the entire claim goes. Now let us come to the documents, the exhibits on record. Kindly take একটু বার করো কাগজগুলো একটু বার করে দাও কোথায় কি আছে Exhibit 3.
Exhibit 3.
Yes. That your lordship will find in Judge's Brief, Volume 6. পেজটা দাওনি বাবা This is a smaller one, page 6, consisting of 2 letters. দেখে নাও দেখো দাও আচ্ছা kindly show the original exhibit file.
All documents are not in the original exhibit file. Some are in judge's brief.
That is why I suggested that a compilation may
That
be
should be
prepared.
done. So that I
Otherwise,
can also underline.
Yes,
Can you come with that compilation?
but I thought the plaintiff would do that because, or both of us can sit together and
Better.
better.
Because some of the documents are marked in the judge's brief,
Right.
some are in
Right.
file. Very
I
difficult.
don't want
to read on.
any controversy after
You
I
sit
place.
together and prepare a common note.
Yes.
Common compilation.
May I just show this document at least? দেখা জজ সাহেবকে চিঠিটা দেই এক্সিবিট
X for identification, then exhibit 3.
Yes. This is from the defendant to the plaintiff. Defendant means defendant, my lord, predecessor in interest of the defendant. That has been cleared, my lord, in the deposition. We enclosed herewith the tenancy agreement for your premises number such and such in duplicate, together with our check for rupees 33075, being the equivalent amount of 3 months rent towards security deposit. Please return us the duplicate copy of the agreement duly confirmed by you that you accept the same and also acknowledge receipt of our check sent herewith. Kindly, Milord, may I just read out? Otherwise, it will be, Milord, inconvenient. Question number 86 to 89 of.
Then, you know,
Kindly keep that, Milord. I shall show a letter of the same date.
question that means deposition.
Deposition of the plaintiff's witness. Question number 86 to 89.
That 86 to 89.
86 to 89. First, in cross-examination, kindly look at clause 4 of Exhibit B. I shall place before Lord.
Interest paid that amount.
Yes. The defense paid that amount. That is that confirmation of the contents of this letter. Can you recall whether the plaintiff acknowledged in writing such and such thing? He must have given the receipt when we received the amount. Can you recall the date of such receipt? No. If I tell you that the letter dated 30th October addressed to Bajbaj so and so, the predecessor in interest of the present defendant, the plaintiff have acknowledged the receipt of the letter dated 29th October 1973 of the predecessor in interest of the defendant, along with the tenancy agreement of the suit premises and an amount of rupees 36 so and so in terms of clause 4 of the said agreement. Would you contradict my statement? I will not be able to contradict, but I will not confirm it also. The letter dated 29th October 1973 is marked Exhibit 1. Correct? It should be 3. Because your lordship will kindly come to question number 98 to 100. Huh?
Yes, that is admitted. Predecessor in interest sent it, accepted so and so.
Now, along with this, if your lordship kindly consider Exhibit B. Exhibit B. Original Exhibit D.
এইটা রেখে দাও।
এই এটাকে কর নয় তো কেউ প্রসিড করতে পারবে।
Then Exhibit B you said.
Senior নয়।
Exhibit B, yes.
This is Miller 29th October 1973, the tenancy agreement. Miller, this is that letter dated 29th October 1973, addressed to Calcutta, Gujarati, and Miller. Kindly ignore for the timing the type copy. Yours faithfully, second page. Bajbaj amalgamated, etc. And confirmed, after that confirmed.
So there is no dispute that this is done by predecessor in interest and that is a continuation. There is no dispute.
No dispute. Kindly come to this Exhibit B, the conditions of the tenancy agreement. Kindly look at Milord. First paragraph, it refers to tenancy of the 9th floor of that premises. I'm just pointing out the main points. Clause 1 the area of the tenanted portion. Clause 2, that we agree to pay you monthly rent of rupees such and such, we think just and reasonable. The rent will be inclusive of owners and occupiers' share of corporation tax. Any enhancement of occupiers' tax from the present level will be borne by us, and the same will be payable separately along with the rent each month. The monthly rent shall be paid by us in advance each month, not later than 7th of such month according to the English calendar month. 3. The tenancy commences on and from 16th October 1973, when 1956 as was in force. Then 4, this is important, that we agree to maintain with you an amount equivalent to 3 months' rent, that is rupees 33075.00, towards security deposit, which amount will not bear any interest. The amount will be paid along with signing of this agreement. This is the amount which is referred to in the first letter I have placed before.
Yes.
So there is no confusion anywhere. Then, my lord, kindly come, my lord, ignore for the timing other conditions of the tenancy agreement. 14, that we agree to take all reasonable care, etc. Then 15 is
Not for residential purpose.
Then 16, that non-payment of rent in time and breach of our part of any time within specified terms and conditions by us would amount to and treated by you as a default on our part, and we shall be liable for eviction. So this clause 16 has got two parts. One is non-payment of rent in time, meaning thereby by whom? By the defendant, the tenant, not by the landlord. And breach on our part of any of the within specified terms and conditions by us would amount to and treated by you as default. So these are the two grounds mentioned in the tenancy agreement. One is non-payment of rent, and the second one is, my lord, breach. Then 17, that we agree to give a minimum 3 calendar month notice before termination of tenancy of the premises. On termination of tenancy, we agree to hand over vacant and peaceful possession to you. Now, pausing here for a moment. In the plain, they say that there is no arrear of rent. In the plain, they have not alleged that any breach has been done by us. Paragraph 5 of the plaint says I have paid rent up to August
Para
2000.
4 stated default of rent.
Pardon?
Para 4 says there is a default in making payment of rent.
That is the London City Civil Court suit.
And reasonable requirement.
There.
There,
Not
yes.
in it. Paragraph 5, kindly look at paragraph
Yes,
5.
yes. Para 5.
Up to August 2003, I paid.
Achha, there was renewal. There was renewal, the acceptance of rent subsequent thereto.
So that suit goes. But there is a specific admission on the part of the plaintiff that there is no default of payment of rent by us up to August 2003.
Your point is that in para 6, society called upon the defendant to deliver a vacant peaceful possession so and so 106 notice, not on the ground of default of rent.
My lord, I couldn't have put it in. Or on a breach, or any breach.
Now, according to your argument, non-payment of rent liable for eviction.
my lord.
Paragraph 16.
My lord.
It is not there.
It is not none of the two conditions.
Or 17. When this notice was given?
In July 2003. Possibly 7 July or something. 5th July. Whatever may be the case made out there, in the plain they have not alleged that there any area of rent, there is any area of rent, and they made no any claim.
That's why there is a breach of this agreement, breach of this covenant.
Now, what is the breach of covenant?
16 and 17.
They have not alleged in the plaint, this plaint. Reasonable requirement in earlier suit won't.
No, that is not.
So, in the present criminal, I again beseech your lordship to look at the plaint. They say I give the notice under 106. You have become trespasser on and from 1st September 2000.
So neither 16 nor 17 are followed
Applicable here.
So according to you, this termination is bad.
I shall make submission on that.
Come on the next date with the compilation. Both of you sit in and make a compilation.
Kindly, কবের মধ্যে করবি বল এরকম ভাবে তো হবে আরে হয়ে যাবে kindly give a direction so that it can be complied with.
Heard Mr. Ghosh, the learned senior counsel for the defendant, comma in part. Further argument is referred to capital পরে বলছি. The parties either jointly or severally shall prepare a compilation of documentary evidence
Indicating the exhibit numbers and Milord.
indicating the exhibit numbers. Shall compilation of copies of exhibits. Shall prepare a compilation of copies of the exhibits. Indicating the exhibit numbers. Such semicolon, such compilation shall contain both the plaintiff, both the parties' exhibits to facilitate hearing of the suit, hearing argument of the suit. Date, when should I fix? How long would you take? 2 weeks?
2 weeks.
Date bolo. 25th?
কি করবেন 10টায় 6টা 7টা ব্রিফ দেখবে
না না আরেকটা আলাদা সাপ্লিমেন্টারি যদি করে দেওয়া যায়
একসাথে করলে কম্পাইলেশন চাইলে
কম্পাইলেশনটা দিয়ে দিলাম দেখতে সুবিধা হবে না
I have not to beat on the bush. Some exhibits are in the judge's brief, some exhibits are in the file. That creates a problem, lot of problems. Because sometimes I may have to make marks. That will be a difficult thing. 25th?
15th তো next Monday.
Monday.
আমার তো ঠিক আছে
Today is 10th.
Already we have long weekend.
Long weekend. 25, I'm saying 25.
Lordship,
14 days. 25th.
Grateful.
Have you noted that?
Yes, I'll look into it.
Twenty-eight, 29, any witnesses present?
Witness is present.
Yes. I am deferring it because I have some problem today. Telling you frankly, my air coat has become suddenly ill. He is burdened with all these things.
Oh.
No,
So he is sent back home. He has to take all dictations, depositions, and everything.
no, my lord. Any day. Any day.
Any day.
Our witness is here today, my lord. Any day is subject to your lordship's convenience. Just, my lord, could it be after 27th in that case?
27.
27th of April. Any day after 27th.
আমি ये কবে রাখলাম ক্রিমিনালটা কবে রাখলাম 29 রাখলাম তো না 29 আমি তোমাকে নোট করতে বললাম 29 এর ফার্স্ট মে তো সেকেন্ড মে
Yes. Would your lordship be pleased to record that the witness was present in court, my lord? That
witness is present in the court today for unforeseen circumstances no দরকার নেই however the matter is referred to May বললাম না May for witness action. The suit is deferred to May for witness action.
deeply.
Is it a case of commercial dispute?
No, my lord. On the last occasion,
Yes.
your lordship had asked both
Commercial
the parties.
dispute, yes, sir.
Your lordship had asked both the parties whether there was a commercial dispute aspect involved in the matter. If your lordship takes your last order dated 7th March 2024, after hearing both the parties, your lordship had recorded a point was raised as to whether the suit should be transferred to the commercial division or not. Mr. Sengupta submitted that in view of pecuniary value of the suit, which is rupees 4,52,000.
Then it will not go.
The
Yes.
matter will not be transferred. That was
Then it
already
will not go.
Yes, pecuniary value.
Yes.
Deeply.